Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, was it populism? Understanding merger review during the Trump administration. As we head into a new administration still forming, in 2021, the time seems right to start looking back and seeing with a little bit of perspective what things looked like in the last administration. Now, there have been some knee-jerk reactions to suggest merger enforcement was lax or non-existent, but I think the answer is a little bit more complicated than that. And today we have guests who have written a very, very interesting piece in Antitrust Magazine, thinking about how to place the Trump administration's merger review record in perspective. Today, we're going to be talking about a very interesting piece in Antitrust Magazine, and I had read this piece and wanted to get these guests on the program right away. Again, I would commend you to the article, which is in the summer edition, and it's called "Populist Instincts: A Trump Administration Merger Retrospective." We have the primary authors of that piece, Peter McCormack and Katie Drummonds, with us today to talk a little bit about, how they put the piece together and some of the key points. Peter, Katie, welcome to the program.
Hi, John. Thank you so much for having us. It's a pleasure to be here.
Yes, very excited to join you. Thank you.
All right. So, Peter, maybe let's start with you. What inspired you to write this article? What were the key messages, key themes that you were trying to bring out from this article?
Yeah, thank you, John. And first, I just wanted to start with the standard disclaimer that these are my opinions and they don't necessarily reflect the opinions of either my firm or any of our clients. With that disclaimer, I think the motivation for this article was, as Katie, Emily, and Andrea and I were sitting and talking about changes in antitrust merger review over the last few months and over the last few years, it occurred to us that it would be a useful exercise to take inventory of what changed and maybe when it changed, and how precisely those changes took place and how we got to where we are today. So with that, we decided to take a really close look at each of the merger consents and complaints that were brought during the Trump administration and share some of our takeaways based on that review.
Yeah, and Andrea and Emily, is Andrea Marino and Emily Hsu. You're all lawyers at the Kirkland and Ellis law firm. Andrea is a friend of the podcast, and Emily is also one of the co-authors. So, Katie, what would you say are the big takeaways from this article?
So I think that, the overall takeaway is that, while the beginnings of the Trump administration may have been, more in the kind of traditional Republican regime, you began to see a shift in probably the later half of the administration that kind of brought to the forefront a consensus, kind of a populist wave that antitrust enforcement had not been sufficient to counter the rising power of certain companies in our economy. And you saw kind of two major shifts. I think we saw that the treatment of vertical deals, we saw that, traditionally you would have seen some behavioral remedies, and instead the agencies seem much more keen to push for divestitures in certain situations. And then also there's a growing focus on kind of killer acquisitions, impacts of deals on nascent competition, that, we hadn't quite seen that level of focus in that area before. And I think you've seen those themes continue into this administration as well.
Yeah, I agree. Sorry, John, don't mean to interrupt you, but I agree with what Katie just said. And just to add on to that, I think, towards the end of the Obama administration, the second Obama administration, there was a growing bipartisan populist sentiment. I think that certain institutions, to Katie's point, had become, perceived as being powerful. And that sentiment gradually started to carry over to antitrust. Towards the end of the Obama administration, then I think, although early in the administration of Donald Trump, I think we saw it really pick up steam in the second half of the Trump administration. And in particular, once you had a full slate of FTC commissioners that were reviewing specific deals and grappling with some of the issues that had been discussed, had been percolating, and certainly at an academic level and even in regulatory circles. But then I think started to become much more of a live issue during the Trump administration. And there were, I think, really, to Katie's point, two things going on politically with respect to political influence in merger review. On the one hand, you had alleged influence in specific matters, and we profiled matters like AT&T Time Warner, obviously, where then candidate Trump had some statements that were rather charged on the campaign trail. But it extended throughout his administration, allegations of political influence, and you saw that in CVS Aetna, and you saw that in Sprint T-Mobile. You also saw the other side of it was more a rising influence of populist instincts, and that's sort of the genesis of our title here of this article. And the feel, to Katie's point, that there was a gap and more needs to be done, whether it's vertical merger enforcement or something else. I think it led a lot of officials at the DOJ and the FTC to look very carefully at the policies that were underlying merger enforcement decisions and explore whether there are ways outside of even the consumer welfare standard that we need to start evaluating deals differently.
So the article is about the Trump administration, but it feels a lot like some of the concepts. Katie, you mentioned vertical mergers and you mentioned killer acquisitions. Those weren't necessarily new in 2017. And as I think, Katie, you said as well, they continue to be sort of hot issues now. Why do you think that is? You've hit on a couple of issues that were hot during the Trump administration. You sort of talk about them being part of the populist view, yet they continue. Why is that?
Yeah, to your point about, these issues were not new, and that's completely true. I think what was new was kind of a rise of focus both in academia and in the press on these issues. I mean, I remember reading back in law school John Quokka's 2015 merger remedy study that came out, and I think got a lot of traction and sort of bipartisan interest in whether the way that agencies have been treating remedies, but specifically vertical remedies, had been working properly. And then you saw, press outlets like The Economist, which I think people think is a fairly centrist magazine, I think it started spending a lot of time back in 2016 and forward on whether there is sufficient antitrust enforcement in the country. And I think that just started getting more and more traction with the general public, to where politicians sort of started to stand up and take notice of this. And so I think you've seen both parties have an interest in making themselves out as, being more aggressive in the antitrust realm, because these issues have just simply become more mainstream. I think the ordinary American is much more familiar with the word antitrust than they were 5 years ago. And I think politicians have adjusted to that, as have regulators.
Professor Quokka was on our program some time ago. I think it's episode number 71, if you want to listen to it. His view, I'm pretty sure, was that there has been a under-enforcement in mergers going way, way back. and he doesn't. I don't think he really distinguishes between Republican and Democratic administrations. What is it about? What is it about the Trump administration that you think? We talked a little bit about the press and the populist sentiment, but I think you would also, if you run into any of the staff lawyers at either the FTC or the DOJ, they would fight you very hard to say that if you were to suggest that they were influenced at all by by something in the press or even an article in The Economist, something like that. Why do you think it was that during the Trump administration, some of these populist sentiments started to leak into or be related to the merger analysis?
Picking up on something that Katie mentioned a moment ago is the politics of. I think we saw an increasing interest. I mean, look at today. You see Senators Klobuchar and Hawley can agree on very little, but can agree that there needs to be something done in terms of reinvigorating the antitrust enforcement vis-a-vis big tech, at least, if not more broadly, and potentially even introducing legislation to achieve that end if you cannot accomplish it using, the current laws. I know that's not a direct response to your question, but I think just the populist sentiment that's pervaded the political discourse has been, and I agree with what you say about staff lawyers. They would certainly push back on that, and rightfully so. But I think when decision makers have to come, essentially to the Senate and to the House and explain what's going on in merger review, and testify as to what's going on in digital markets and why they're making certain decisions, that turns up the pressure on the regulators to get decisions right. And so I think, the court of public opinion plays a very real role in this. And I think that's certainly, Katie mentioned that there's more of an interest popularly around antitrust today than there was maybe 5 years ago. And I think that may not matter necessarily to the day-to-day staff level work that goes on, but it does matter, I think, at the decision makers level at both agencies, at the commissioner level and at the assistant attorney general level, and with their direct staff.
I want to read the closing paragraph from your article, a couple of sentences, which I found to be very, very interesting. And I just want to get your reaction and maybe discuss a little bit where you're coming from as you came up with this. So here's the conclusion to the article. Statistically, antitrust merger enforcement in the Trump administration converged with the Obama administration, particularly after a full slate of FTC commissioners was confirmed. However, the politics of merger enforcement was drastically different in the Trump era. Perhaps coincidentally, President Trump came into office just as an intense academic debate about horizontal vertical merger enforcement theories and outcomes burst into the mainstream consciousness, propelled by contested high-profile FTC and DOJ litigations and consent orders. This is the part that I found most interesting. When President Trump's populist instincts led the DOJ to intervene in merger cases, most pointedly in AT&T, Time Warner, CVS Aetna, and Sprint T-Mobile, allegations that political motivation influenced the DOJ's intervention, leading to inconsistent or unprincipled results, followed in tow. What? Again, I have heard the political the accusations of political influence. But as you looked at these articles, did the decisions, even the ones you called out, where there was where the president had made some comments, were they drastically different in terms of policy from the path that the Trump administration had been on?
So it's interesting, and I think with each of those three matters, you'd need to address them differently, because when the Trump administration started, AT&T, Time Warner, it essentially raised the issue anew of whether there should be behavioral relief in vertical mergers. So it's set out and defined a space in that sense. And I think a lot of what happened after that, specifically CVS Aetna, where you had the judiciary sort of not second guessing, but looking very closely at what the executive branch had done in the CVS Aetna case, and then finally with respect to Sprint T-Mobile, where you had state attorneys general, diverging from where the DOJ was going. Those three decisions, I thought, it's interesting to think whether a different administration may have taken those specific deals in a different direction.
Yeah, that's really my question, right?
Yeah, I mean, I think if you were to look at, I think, for example, AT&T Time Warner could have potentially been resolved with a vertical consent order that looked a lot like Comcast, NBC, Universal, and that would have changed the vertical discourse at the DOJ and at the FTC during the remainder of the administration. It's hard to say definitively that a different administration would have taken the same tact on that deal. There was, we mentioned in the article and others have in the past that the parties offered final offer arbitration as a behavioral remedy that would essentially seem to resolve many of the bargaining leverage concern that was raised there. So, as to CVS Aetna, it seemed like a different tact was taken where, in the face of vertical concerns, not pursuing litigation was the path chosen by the agency. So there was a bit of a difference in approach. I know the facts of those cases were very different, but so it's difficult to really tell. And I think because the Trump administration set its path so early on, especially at the DOJ, that the path, I think, towards increased intervention would have happened regardless of whether it were a Clinton administration or a Trump administration. But the type of intervention was characteristically different.
I think that's right. And Katie, I think it's impossible to ignore that the president did weigh in on these mergers. And again, it's sort of hard. It's hard to, I don't know, it's cliche, but hard to kind of unring the bell there, right? Once the president weighs in and says this is important, I do think people listen to that. Do you think? I mean, it's hard to speculate about whether there would be, whether there was actual influence. But what do you think about? How does that play into government review when you have politicians weighing in on these types of mergers? I'll direct that to either Peter or to Katie.
Yeah, I think that's right. And while I agree that staff attorneys would never want to say that they're influenced by factors such as what's said in the press or et cetera, but I think to Pete's point earlier, if you're a high-level official in the Department of Justice and the leader of the executive branch makes a statement about a particular case, you're going to have to respond to that and consider that. And I think probably especially more so at the DOJ potentially than the FTC, but I think the fact that the president was out there making statements about high-profile merger antitrust decisions again speaks to kind of the more mainstream focus that this area has gotten to the point where the president would find it advantageous to speak out about these types of matters, where I don't think you'd really seen that in the previous administration as much.
Or at all. I think.
So I'll let Pete weigh in as well.
Sorry, I agree. Or at all. I think a lot of folks in the press would argue that the nature of antitrust dramatically changed and became way more politicized than ever before, especially at the DOJ. That's an opinion we've seen in the press. We chronicle that. I don't have an opinion necessarily on that particular topic. I would note that, talking on the campaign trail about too much concentration in the hands of too few. That goes back to the populist rhetoric that I think, Del Rahim's AAG Del Rahim in a speech, I think it was in 2018 or maybe early 2019 said, politicization does an extreme disservice to the American public in the context of antitrust review. And I think that's completely true, regardless of what party is influencing or what the politics are. I think And that's the great struggle that we as antitrust practitioners have today, is to help guide in using our good faith efforts to try to guide antitrust principles to the right direction that are both applicable, reliable, and can be used by the business community and by practitioners alike.
And when there's an investigation pending, I mean, I think my experience has been, lawyers, leaders at both agencies, so it's the FTC and the DOJ, are scrupulous about not commenting on, not trying to prejudge it, and I think when you have the president of the United States, who's the boss's boss of the FTC chair or the AAG, right? When you have the president weighing in, it puts the staff lawyers in a tough spot, because if they agree with the president, putting aside whatever he said, if they agree with the president, well, now they're going to be accused of making a decision on political grounds. If they disagree with the president, that might be even worse. So it's just a really difficult position, and I tend to agree with AAG at Delrahim on this, that the politicization of merger reviews, it makes things harder.
Yeah, I don't envy the position of staff lawyers who have to weigh in or run a deal where the executive branch is releasing, statements about that specific deal, or where you're reading about that specific deal in the New York Times and the Wall Street Journal op-ed pages, from day to day.
And I make a distinction, of course, between a leader who might talk generally about the level of concentration, right? Just we think there's too much concentration in the world, or we're going to prioritize this type of review or that type of review. That happens all the time. It's the comments on the specific mergers that I think are different.
Well, right. And like the Obama administration, the Council of Economic Advisors, which we cite in the paper, they said as much in the I think it was benefits of competition and indicators of market power. That was writ large, there's a consolidation problem. It's leading to economic disparity. It's leading to, not necessarily, empirically better results for consumers. But definitely it's resulting in higher profits for the firms that are engaging in consolidation. So that's what that paper stood for, and other academic papers by Quokka and other, heavily empirical based researchers in this field. And, I think that is helpful, fodder to get people to think more reflectively about what the right standards are and how to apply them. And I agree with you completely that once you start to get, even if it's a populist-backed statement, any kind of political statement in the context of a specific merger review is just not helpful.
All right, so I'm going to ask each of you for one key. What's the one key takeaway for each of you? So total of two. Well, for each of you? What is a key takeaway that we should have from this? What are the lessons we should learn? What should we really take into account based on this extensive article you've written?
I'm going to give Katie the opportunity to go first, which could be a blessing or a curse. But Katie, go ahead. You go first.
Sure. So I think in addition to the points I mentioned at the beginning of our session, I think the big takeaway is just that there's kind of a bipartisan, populist inclination to question the traditional antitrust framework, around the consumer welfare standard. And so I think I've seen a shift, both in the Trump administration and today's administration, to focus not just on, quantitative effects on efficiency and price, but, really looking at more qualitative issues that might be a little closer to the interest of the American public, like impacts on product quality, the things that they use every day, impacts on labor, impacts on innovation, potential impacts on political power, and even, today in today's environment, impact on climate change. I think that's the biggest takeaway. It's just the shift away from the traditional economic framework to considering more qualitative issues that might be a little closer to home to the American public.
And it's a really, really insightful point, because the antitrust world kind of has been fascinated with the Biden administration's discussion about, is the consumer welfare standard still the right way to look at this? And Katie, I think you're right. If I take your point, the seeds were sown, in the last administration for this rethink.
Yeah, I think that's right. I think it's been a bipartisan shift in many respects.
All right, Pete, try to top that.
Yeah, I don't think I can. Katie took the good one. We talked about this, so I guess that was the blessing part of it. You read the paragraph at the end. I would say that was one of the paragraphs that I reflect upon as well. The one other one I'll cite is that we mentioned that, Democratic administrations have tended to bring more enforcement actions. Republicans shown more restraint, but the amplitude of change in enforcement has been marginal. I think that's going to continue to be the case. I think we're going to continue to see both Republican and Democratic administrations to push the envelope on merger enforcement, to redefine what the standard of merger enforcement is or should be. I think we're going to see more things like focus on potential competition, labor monopsony, conglomerate effects, and any kind of things that you may have seen in the 1980s types of guidelines be reinvigorated. And so our review of the Trump administration's 4 years of antitrust merger policy and review indicates that, there were some interesting political things that happened, but the tide, I think, of increased merger enforcement is something that goes beyond the Trump administration, is bigger than the Trump administration, and that we'll see this going on in the years to come. And how it'll take shape is I think, the big excitement and also the big fear of some practitioners today.
Okay, this is a new segment we're doing. On our website, we have a device. It's called like a speak pipe or something, and you push a button and you can ask a question into the website. And then when you ask that question, we get it. And then we will ask that question to panelists on a future program. Today, we don't have exactly that. Today, we have Emily Hsu, who is the MVP of this article. And she is going to play the role of somebody who has asked a question into a speak pipe. Emily, go ahead. What is your question for these panelists?
So, Pete and Katie, what role can the courts play in a politicized or shifting antitrust regulatory environment?
Katie, you first.
I think they're going to have to play a large role. As regulators are considering, pushing the bounds of antitrust enforcement and trying to really redefine, antitrust standards and bring, more outright blocks of deals. Eventually, I think parties are going to have to take them to court so that, we can get more precedent on the books around antitrust, specifically, merger enforcement. There's been a kind of a dearth of case law, particularly around certain issues such as vertical merger enforcement and efficiencies, especially. So I think we're going to have to see the courts play a large role in a lot of these areas where regulators are going to be much more aggressive, and parties might want courts to be the ones to really define the outer limits of their enforcement power.
I agree. I think some parties may already be looking at litigation as a tactic to resolve, particularly litigating the fix where, there's a divestiture that can be or other remedy that can be offered that attempts to resolve the government's concern, and you sort of litigate on that basis. That's been successfully done. That was going to be successfully done or potentially successfully done in Illumina Grail. But the government withdrew its complaints. I think that the courts and parties are already looking at the courts as a potential sounding board, or not sounding board, but place to test the DOJ and FTC if they're bringing cases on theories that may be novel.
Well, and the problem is, I think that there is a limited amount of resources at the agencies. So in some ways, broadly, there could be a strategy of trying to stretch the agencies very thin with a large number of court challenges. And I think, and those who are interested in more aggressive enforcement, I think, face a judge problem, because judges typically have lifetime tenure, and not covered in your article, but the last administration appointed an awful lot of judges who are probably, notwithstanding the person who appointed them, probably are going to have a fairly traditional and conservative view on the antitrust law. So I think that the courts could be a real damper on the agencies, absent a legislative fix.
And certainly with respect to vertical deals, because to Katie's point, there's been a pretty limited track record of success by the agencies litigating vertical deals. And until and unless they can win one in court, parties may be, to your point, John, have the incentive to, plan for litigation.
All right, I'm going to shift gears just a little bit. We're going to shift gears a couple times between now and the end, but this is one shift. Katie, Peter, talk to me about writing the article for Antitrust Magazine. If just for some of our folks who haven't done that yet, what was the experience like? Was it a good experience? Is it something that's worth doing? I know it's obviously when you write something of this quality, it takes a lot of work. Is it worth it?
Absolutely. This was very cool. We had a great time doing it. We had a lot of, especially during, this sort of COVID period where folks have had lumpy schedules. We had the chance to, do a few Zooms, get face to face, and grapple with some of these issues. I think that have helped us. The process has helped our practice, frankly, in this area, because everything is changing so quickly. To take that inventory that I mentioned and understand what's going on and how can I find takeaways for my own personal practice. I think every one of us were able to glean that from this process. So I found it incredibly rewarding, and I would do it again.
Katie, what about you? How was the editing process, and how was it working with the staff over there?
Yeah, I think it went really smoothly. I also want to definitely give a big shout out to Emily, who was paramount both in the research and the editing process. So she was definitely the MVP of getting this article across the finish line. But I think it was just really rewarding to, take a step back from your everyday matters, where you're really in the weeds and kind of look at the trajectory of where our practice is going and the key issues that are animating the bar right now. So I think it was super rewarding to kind of feel like you're a part of the bigger picture. And the staff at were great in terms of the editing process.
Antitrust Magazine, I think, is probably the preeminent periodical source for real substantive antitrust. You can get antitrust other places, but if you want things that are not short of a law review article, but not a brief summary, it's really the place to go. I really commend folks to go check it out. I have an article in there, this issue as well.
I would also shout out to Tina Miller, who is a terrific editor, and also David Wales, who was the editor assigned to this one, and gave us a lot of great comments that I thought helped improve it. So thanks to them as well.
Yeah, it's a nice collaborative group. So folks have ideas. Get in touch with the folks at Antitrust Magazine. It's really a terrific way to write. Okay, shifting gears again. Katie, let's start with you. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Sure. I think a big hobby of mine is fantasy football. I don't think I'm unique in that respect, but I'm the proud champion of a Georgetown Law Alumni League that I've been in for almost a decade. Finally brought home that championship last year, which was a proud moment for me.
Okay, what's your team name?
It was, I believe, Jones and Fertana Thrill. I'm a big Tennessee Titans fan, so Ryan Tannehill is my quarterback of choice.
Interesting. Do you ever find yourself sitting in a bar on a Sunday, screaming at a guy for taking a knee at the end of a half?
No, my teams are normally up by enough points. I don't need to worry about that.
Point taken. Peter, how about you? Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
So I may tell people this professionally, but so they may have to endure my personal stories. But you certainly would not know this by looking at me. But I am in my high school's Cistercian prep school in Dallas, Texas, is Hall of Fame for basketball. I had a 3-year varsity career where my shooting percentage was 48% over my career. So there was a minimum shot. Your question, John, would be like, hey, did you take like 5 shots over the course of your career? No, I think there was a 500 shot minimum to qualify. So that's my, you wouldn't know it if you ever met me and I didn't tell you.
I had you as like the dunk champion. Have you ever been in a dunking contest at your high school?
I used to do plyometrics, those box jumps that help get your calves all ripped so you can like slam it down. But no, that was never anything that was able to, I could get my, a couple of my fingers over the rim. So like, if I had one of those kids balls, like I have, at home with my kids, I'd be able to slam one of those maybe back if I was 17, but that was as close as I got.
Does shooting percentage in high school basketball help you at Pop-A-Shot?
I'd say it helps your antitrust deal judgment because especially if you have, if you make half of the shots that you take in basketball, where, traditionally people make maybe 3 out of 10, I think that shows prudence and judgment that although my Pop-A-Shot skills are pretty good, John, I don't think I stand above anybody on that. I actually the pressure in Pop-A-Shot actually works against me sometimes.
Is that right? Because I would say in the antitrust bar, I would probably pick you on my Pop-A-Shot champion fantasy team.
I'm honored, and I would certainly participate if that's a real thing.
Okay. I'm not sure it is, but let's stay in touch. Katie, Emily, Peter, thank you for joining us. The article is called Populist Instincts, a Trump Administration Antitrust Merger Retrospective. You can check it out in the summer edition of Antitrust Magazine. And we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.